I've got a hearing.
Well, yeah, they
Columbia
call it cats, right?
Huh? Yeah.
Do you want? Should I watch on YouTube or?
Sure.
What? Okay.
Yeah.
Oh, you shut the door?
Yeah.
Good morning, everybody. Mr. Wilson's here. Mr. Wilson, is Mr. Valcarengi joining us at some point? Can't hear you, sir.
I expect that he is. Yes, he's supposed
Okay.
to.
Okay, well, we can, I know, I've seen him. I know he's in the building this morning, so we can go ahead and start. Mr. Court Reporter or Miss Court Reporter, are you ready?
I'm ready, Your Honor.
All right. All right. Good morning, everyone. My name is Chuck McLean. I'm the Chief Public Utility Law Judge at the Maryland Public Service Commission. Today is September 13th, 2023. It's approximately 10 o'clock in the morning. We're here for a settlement hearing in case number 9701, which is captioned Columbia Gas of Maryland, Inc.'s application for authority to increase rates and charges for natural gas services. And we can start with appearances. We can start with the company.
Yes, good morning, Your Honor. Carville Collins for Columbia Gas of Maryland, and I have with me today, also on this call, Ted Gallagher, Assistant General Counsel, and Candace Tanillo, Senior Counsel with Columbia Gas of Maryland. Thank you.
Good morning. OPC.
Good morning, Your Honor. Ryan Shu on behalf of OPC.
Morning, sir. MEA.
Morning, Your Honor. Steve Tolson, Assistant Attorney General on behalf of the Maryland Energy Administration.
Note that Mr. Alexander has also joined the call for OPC. Mr. Wilson.
Yes, Your Honor. Peter Wilson on behalf of Staff Counsel. Also joining me is Harrison Scher. And we're expecting, as you know, David Valcarengi.
I can see him now. Yeah. All right. Thank you for joining us, Mr. Valcarengi. Before we get to you, I know Mr. Marquise, Mr. Collins, I appreciate your email, reaching out to him. I know that he received, obviously, the settlement agreement. I know that he's received the terms of it as well, and he was invited to the hearing today, but it doesn't look like at least he's joined us yet. Why don't we start with the exhibits, get everything admitted first, and then, like I said, I just have a couple what I hope to be clarifying questions for Mr. Valcarengi, and then one for probably it's most appropriate for counsel. Mr. Collins, Mr. Gallagher, Ms. Tanillo, who wants to kick things off?
Your Honor, thank you. I'll kick it off, and I propose to proceed as you instruct, Your Honor. Yesterday at about 4:14 p.m., hopefully all the parties received a copy of Columbia Gas's list of exhibits. It was sent at 4:14 p.m. by email from Ted Gallagher, and it is a comprehensive list of all exhibits. There's a total of 38, plus several of them have a letter designation. And I can read through these, or we could just take them as a group. I'm happy to proceed in any fashion that you direct, Your Honor. But my proposal would be that we mark them, and if there are no objections, we move them into the record at some point. Can we do it as a group, or shall we do it individually by working through the list?
I would agree with you with your proposal, unless there's an objection to that. Okay, so I'm seeing no. And what I may do, Mr. Collins, if this is okay with you, is maybe just make the exhibit list exhibit 39. It might just be easier for anyone who actually goes back and wants to look at this case.
That would be fine, Your Honor. That actually, we did have that in mind, wanted to move that one in as a final item. So why don't I just, for the record, request that this list of Columbia Gas exhibits in case number 9701, Columbia Gas of Maryland 2023 base rate case, be marked as Columbia Gas exhibit 39. And if there are no objections, we would move that into the record as well.
All right. So is any objection? It'll be so marked. Any objection to moving Columbia Gas exhibit A through D, and then 1 through 39 into the record?
No, Your Honor.
No, Your Honor.
All right, thank you. Seeing none, they are admitted. We can move to Mr. Tolson.
Good morning, Your Honor. MEA only has one exhibit, and that is the direct testimony of Paul G. Penske, Director of the Maryland Energy Administration, that was filed on July 26, 2023 under mail log number 304276. We would like to have that marked as MEA Exhibit 1 for identification, and having so marked it, we would move for its admission into the record.
It'll be marked and admitted, sir. Thank you. Mr. Shu?
Thank you, Your Honor. OPC has a few. I'd like first marked as Exhibit 1, the direct testimony of Colin T. Fitzhenry, submitted July 26, consisting of 17 pages, 1 appendix, and 2 exhibits, marked as OPC 1. I guess I'll just go through and mark them all.
That'll be fine.
That's fine. Yeah, it works. I would like the direct testimony of James S. Guerin, submitted July 26, 2023, consisting of 21 pages and 3 exhibits, submitted on July 26, marked as OPC Exhibit 2. OPC Exhibit 3, direct testimony of David J. Garrett, submitted July 26, consisting of 87 pages, 2 appendices, and 17 exhibits, marked as OPC 3, please. The direct testimony of Jerome D. Mirzwa, submitted on July 26, consisting of 43 pages, 1 appendix, and 1 exhibit, marked as OPC 4. The rebuttal testimony of Jerome D. Mirzwa, submitted on August 16th, consisting of 14 pages, marked as OPC 5. The direct testimony of Greg R. Meyer, submitted July 26, consisting of 29 pages, 1 appendix, 1 exhibit, marked as OPC 6. And then as OPC 7, the supplemental testimony of Greg R. Meyer, submitted September 11th, consisting of 4 pages. And I would like, if there's no objections, I would like that entered into evidence.
No objections.
No objections.
Your Honor.
All right, I was muted. I apologize. They're marked and admitted. Mr. Shu, did you want to formally correct that one issue I noted on the property tax rate? There's
Yeah,
no
sure.
necessarily- Go ahead.
Sure, Your Honor. Sorry, let me just pull up the actual numbers themselves. So yes, on page 3 of Mr. Myers' supplemental testimony, OPC 7, on page 3, line 18, he inadvertently refers to an effective property tax rate of 1.1651. This should actually be 1.3978.
Thank you, sir. I appreciate that.
Thank you.
Staff.
Your Honor, staff has 9 exhibits, all of which have been filed and are in the docket of this case. The first 7 were all filed as mail log 304274, and I'll run through them briefly. If we could mark as staff exhibit 1, the direct testimony of Tanyika Alexander, which includes exhibits. Mark as staff 2, exhibit 2, the direct testimony of Pamela Coates with exhibits. Mark as staff exhibit 3, the direct testimony of Alden Manka with exhibits. Staff exhibit 4 to be marked, direct testimony of Drew McAuliffe and exhibits. Staff number 5, the direct testimony of Lucy Shea, including the exhibits. Staff exhibit 6, the direct testimony of David Valcarengi, which includes exhibits. And then staff exhibit 7 is the direct testimony of Carlos Acosta, which was filed in both a public and confidential version. I'd ask that the public version be marked staff exhibit 7 and the confidential staff exhibit C. Under mail log 304607 filed on August 16th of 2023, we have the rebuttal testimony of Lucy Shea, which I would ask to be marked as staff exhibit 8. And in mail log 304959, filed on September 11th, 2023, I would ask that the testimony in support of settlement of Mr. McAuliffe and Mr. Valcarengi be marked as staff exhibit 9. And I would ask for the entry into evidence staff exhibits 1 through 9.
No objection?
No objection. I believe Your Honor is muted again, though.
Thank you. I apologize again, trying to be efficient here, but yeah, they are marked and admitted. Thank you, Mr. Wilson. Before we get to my questions and Mr. Valcarengi, I would note that it certainly appears that Mr. Marquess was on board with the settlement. I know he's not a signatory to it, but and please correct me if I'm wrong here, but on Wednesday, September 6, 2023 at 12:50, he responded to an email that I had sent him asking whether or not he was going to file testimony in support of or in opposition to the settlement. And he stated, "Hello, Your Honor, I'm in support of the settlement agreement and can make myself available on 9/13 if needed. Thank you." Is everyone's understanding that Mr. Marquess is in fact in favor of the settlement?
That is staff's understanding.
Yeah, I believe so, Your Honor.
All right. Thank you for confirming that. I appreciate that. I just want to make sure that the record was clear. All right. And with that, anybody have anything else before we get to Mr. Valcarengi? All right. All right. Mr. Valcarengi, I'll swear you if you could raise your right hand, please, sir. Do you swear or affirm under the penalties of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Can you please state your name and spell it, please?
My name is David Valcarengi, last name Valcarenghi.
Thank you very much, sir. I appreciate you being here today. Hopefully these will just be easy ones for you. Do you have the settlement in front of you, sir?
I do.
All right. On page 3 on rate case expenses,
Yes.
it says actual rate case expenses up to the filing of the joint motion will be amortized over 1 year. But since this is a black box settlement and we don't know how much those expenses are, is that more of just a statement saying that there won't be any rate case expenses sought by the company in the next rate case, save whatever costs may have been incurred after the joint motion was filed?
Well, I think what it's indicating is the level of costs that were reflected through the hearing are implicit within the revenue requirement, and any cost, like for today's hearing, could possibly be sought in a hearing next year.
So I think we might be stating the same thing. So to the extent that there are additional rate case expenses for 9701, those would just be post filing of the joint motion.
Yes.
Okay. And is it my understanding that the parties are also agreeing that Columbia can at least seek those additional costs? Is that your understanding, Mr. Valcarengi?
Oh, I'm sorry. I thought you were directing that to the parties.
It's okay.
Yes, that's fine.
Is that your understanding?
It is my understanding.
Okay. And council, I assume that's everyone else's understanding as well.
It is.
All right.
Yes.
All right. Thank you for confirming that. Next page, sir, under F, other proceedings. I'm looking at page 4.
Yes.
There's a reference to, I guess, the most recent Stride case 9479 and setting the overall rate of return for that case at 7.2. Now, is that simply for the reconciliation associated with that case?
Yeah, there's some, I guess I would call it unrecovered costs that are floating from the last, will that be Stride 2, that will be subsumed into Stride 3, which is being litigated in 9709.
Okay. All right. Thank you, sir. I appreciate that. And this is more of a curiosity question. I know with these settlements, many times They'll include both return on, excuse me, a return on equity and a rate of return, but there's no agreed upon return on equity in this case. Is there, do you know if there's a particular reason why, or was it unnecessary in this case?
It's not really necessary on a moving forward basis. I think the controlling number is the overall rate of return. The company needs that number for Stride, so that the equity number isn't as important as the overall number.
Okay. All right. Thank you, sir. All right. All right. I think that's all I have for you, sir. If you want to stay on just in case something else comes up, I'd appreciate it. Excuse me. My last question. Oh, does anybody else have any questions for Mr. Valcarengi? Based on mine. All right. I'm seeing none. All right. My next question is for council. It's related to the provision on page 6, item M, talking about the RNG. And my question is, this wasn't an issue in our case. I think Mr. Kempick was probably the only person who actually referenced RNG, and I'm talking about renewable natural gas, and that was just maybe a fleeting reference. And you're referring to, this provision refers to a provision that was specifically included in 9680. So my question is, if it was specifically included in 9680, why do we need it in this settlement agreement? And if we do need it in this settlement agreement, my concern is there's nothing in the record to support it.
Your Honor, let me, if I may, I'll begin, and I'll ask Columbia in-house counsel to supplement my answer. This is, you are correct. This was not an issue in this current case. This is a term from the prior case, and it was a term of the settlement in 9680. At the request of the parties, and I believe it was especially the Office of People's Counsel, that term was asked to be included again in this year's case. We all understood that it was repetitive of the settlement term from the prior case in 2022. But at the request of the parties, particularly the Office of People's Counsel, we agreed to include it in this year's settlement. It reflects essentially carryover of an agreed upon a settled issue from the prior case, that we would have that consultation and approval before proceeding with any renewable natural gas in our system.
All right. Thank you, Mr. Collins. And before I turn to OPC, would it be your understanding that there's nothing in this settlement? Let's say this provision wasn't in there. Columbia would still be bound by the settlement agreement in 9680 moving forward. Is that your understanding, sir?
That is our understanding. That is the way we treat that. Any settlement term to which we've agreed in a prior case is still binding on us.
Okay.
And so, yes, this is admittedly repetitive of that. If this was not in there, we would still be obligated under the terms of last year's case and that settlement to comply, and we have every intention of doing so.
All right. Thank you for confirming that, sir. Mr. Shu, Mr. Alexander, it sounds like sounds like OPC, excuse me, were the proponents of this provision. Why do we need it, and where in the record is there any support for that, the inclusion of this provision?
Yes, Your Honor. We pushed for this provision because I think, frankly, it's more of a security thing to make sure that we had it in there. Again, I think, as the parties have indicated, there wasn't this issue in this particular case, so there's not necessarily any underlying talking about or support for it in this case necessarily. But I think, insofar as previous settlement agreement term still applies. I think, it's always acceptable for us. We were just more looking to ensure that this sort of before the introduction of renewable natural gas, that this provision remains sort of front of mind, I suppose. But yeah.
So it was more of a foot stomping / reminder that, hey, Columbia, we agreed to this before.
Yeah, yes, you're right.
Okay. Staff, or MEA, any thoughts or issues with this?
Runner?
Yes, sir, Mr. Alexander.
Just two quick things. What Ryan said is correct. First of all, I ask everybody to forgive Ryan for that Washington Nationals pennant behind him, because he knows not what he does.
They've won more World Series than the Orioles lately, so.
Well, yeah, but we're coming up. The second thing is basically it was requested. Everything Ryan said is accurate, but behind it was a request from OPC management. And so therefore Ryan made sure that it was in. That's all.
Understood. Yeah, I'm not pointing fingers at anyone. I just am trying to figure out the basis for it and where it came from. Because initially I thought I missed something in the case. So, Mr. Wilson, do you have anything to add?
No, I don't. As been stated, staff did not raise this issue in this case. We did in the prior case, but we have no problem with it being included. We have no problem with it being deleted either.
Thank you. Mr. Tolson?
We don't have any position on it either way, Your Honor.
Okay. All right, great. Well, thank you for clarifying that. I appreciate everyone answering my questions. Do we have anything else before we conclude today?
I don't think so, Your Honor. I think we've got it covered.
Okay, great. All right. Well, I will get working on my order. I'll have that out as quickly as I can. And with that, I thank everyone for everyone's work on this case and getting to these settlements. I know a lot of work goes into them, so I appreciate it.
Thank you, Your Honor.
Thank you, Your Honor.
All right. And with that, off the record.
Thank you.
Thank you, Your Honor.
Thank you.